Move on to our next topic here.
Well, we knew this was coming, but unfortunately, I don't think any of us knew exactly how broad this was going to be. Just as a little bit of background, non-compete agreements in California have, for basically the last 15 years, been unenforceable as a matter of law. The public policy of California states that we want employees to be able to move freely, go take new jobs, go work for competitors in the workplace without restrictions or limitations. This goes back to a case back in 2008 that was called Edwards versus Arthur Andersen that basically says, we're not going to allow you to enforce those provisions of non-compete employers, but I will be candid with you. Many employers have chosen over the last 15 years to continue putting non-compete agreements in their severance agreements, in settlement plans, in performance improvement plans during the course of an employee's work for the business. But now they are full-blown illegal. They are unlawful to have a non-compete agreement in the state of California between an employer and an employee. And let me pause there for a moment. If you are selling a business, non-competes can still be used. If it is a business to an independent contractor relationship, that may still include non-compete language. We are only talking about employment relationships, employer to employee on this. But if you have at any point used non-competes in the last 2 years, you must go back and A, modify your agreements moving forward, taking out that non-compete language. And B, we actually had until yesterday, and sorry you're getting this a day late, but we had until yesterday that if you had a non-compete with one of your employees, you had to send them written notice by February 14th. Happy Valentine's Day. You're no longer on a non-compete. To anyone that we had a non-compete agreement with since January 1st, 2022. Now, don't get me wrong, guys. If you missed the deadline of February 14th, I'm still strongly encouraging you to send out those notices. So go back to your prior severance agreements. Make sure that you do not have non-compete language in there. If you do, send out a notice to the employee that indicates the non-compete provision of your severance agreement will no longer be enforceable as of January 1st. All of the remaining terms and conditions of your severance will remain true and will remain in full force and effect. Simple as that. Send that out to those individuals. Let me be perfectly clear on one other element. Employers get this confused all the time. You are still permitted to have in your separation agreements, in any written agreement with your employee, protection of your proprietary rights, confidential client lists, confidential contact information of coworkers and employees, your secret sauce, your KFC 11 herbs and spices, your recipe for Coke. All of that is still protected. You just cannot protect somebody from going to go work for a competitor in the marketplace. They cannot use the information that is proprietary or unique to your business or that is a recognized trade secret, but you can't stop them from going to work for a competitor. That's the differential, and that's what's most important for people to keep in mind. So in the future, as you're issuing severance agreements, when you're separating with an employee, you should have that confidential information and the proprietary information specifically defined so that they know what they can and cannot use if they go work for a competitor.
So, Brian, you had mentioned that, if you had done a non-compete or had that in an agreement in the last 2 years, you have to go back and change it. What if you hired an employee 10 years ago, 12 years ago, 15 years ago, and had that language? What has to happen in a situation like that?
It's only for those agreements that were entered into January 1st, 2022 and later. But you do need to understand that if that employee ever separates, when you give them a separation agreement, you need to specifically delineate that they are released from any prior non-compete agreements.
Got it. Okay. That's interesting. All right. Thank you.
Absolutely. All right.